Good morning, all. This pretrial review is in the matter of CFI 087-2022 before His Excellency Deputy Chief Justice Ali Al-Madhani. The claimant is represented by Horizons & Co. law firm. Lead counsel is Mr. Stephen Docherty. The defendant is represented by MB Kempt LLP, and lead counsel is Mr. Michael Patchett-Joyce. Thank you, Your Excellency.
Thank you very much. Yeah. Well, apparently we have an unpleasant pre-trial review hearing, because I have just seen a complex correspondence between parties related to production of document at this late stage. Is that right, Mr. Doherty?
Your Excellency, perhaps happy to take you through the history. It's both complex PTR in some senses and not complex in the others, because for the most part, directions have been set in relation to witness statements, expert evidence, and so on. The main issue is what's been going on with document production, which is what's likely to impact on trial date, which is an issue I think that's probably the essential issue to flag this morning. It may well be that there are steps that need to be taken this morning to deal with the trial date issue, but if not, it's something that's coming down the track at the parties pretty quickly. If I can go through the sort of history of where we're up to with it, as Your Excellency will be aware, this trial's listed for 4 days, 3 and 1 in reserve, from the 26th to the 29th of November. I'm not going to take you through the whole history, but the long and short of it is that an order was made in respect of document production. That was appealed and stayed, and permission to appeal has been granted. That's the summary of where we're up to. If I can take you through a little of the detail of that, just to give you the context, I think probably the starting point is page 113, if you have a copy of the bundle prepared for this morning.
Well, section C?
Yeah, section C, tab 4.
Yes. Right.
Which set out what the document production process was going to be. So paragraph 3 talks about where there are no objections, production of documents. Paragraph 4, where there are objections, those were to be filed and served 12th of April earlier this year. If a party is not satisfied with the objections, it has to make a Part 23 application in the normal way for a document production order. So the process fixed by the CMC was that the document production phase and any application arising from it would be dealt with in the normal way. That's a Part 23 application.
So the deadline were April 2024, yeah, for the production or request or this decision to be made about the production.
So the 12th of April deadline is for the objections to produce. There was no fixed deadline for any decision to be rendered on document production. So what happened in the procedural chronology is the objections to produce were filed and served in accordance with paragraph 4. And then applications were made by the defendant for a document production order. And this is really an issue for the appeal, so I don't think it needs to be traversed in tremendous detail this morning. But what Part 23 says, the specific rule is 23.69, is there are limited circumstances when court can deal with an application without a hearing. And those are if the parties agree to the terms sought, or that the parties agree that the court could dispose of the application without a hearing, or if the court determines that a hearing isn't appropriate. And what the rules then say is if the court determines of its own volition that there shouldn't be a hearing, it has to treat the order it makes as though it's an order made in the court's own initiative. And what the rules say about that is that if the court makes an order on its own initiative, again, this is Part 4, the rules 4.9 through to 4.13. If you do that, you have to include a provision in the order allowing a party to apply to set it aside. So the default position is if you've got a contested application, there's a hearing. If the court proceeds without a hearing, you've got liberty to apply to set aside. What happened in this instance is the objections to the defendant's request to produce, as I say, were filed and served in the normal way. The document setting out the defendant's request was, I don't think there's any other way of describing it than extensive. It was 76 separate categories of document requests. It was contained in a 116-page schedule. From the claimant's perspective, it sought to get documents in relation to issues which, due to the procedural history of this case, had already been struck out by Justice Sir Jeremy Cook earlier in proceedings. And so, quite rightly, they were robustly contested by the claimants. What then happened is at page 116, so this is Justice Nasser al-Nasser's order in relation to document production. It's 116 and 117, which provides a few recitals, which says, upon the case management order issued in this case, and upon Part 28, and upon the application for a document production order, it is hereby ordered that, and there are 3 paragraphs, 1 which grants all of the requests, and 2 which provides a deadline, and 3 which refers to a document production statement. Now, that order was made without hearing from the parties. It's not clear from the face of the order whether it was made with the benefit of having even reviewed the defendant's objections, which were filed and served in accordance with the CMC timetable. At the very least, we would say, and again, it's a matter for appeal, unclear in my submission whether the court reviewed those objections at all. But in any event, the form of the order doesn't suggest that the court was proceeding on the basis that it had made the decision, it was taking this decision on its own initiative, because there's no paragraph saying liberty to apply to set aside. And where that placed the claimants was that the only route at that stage was to appeal the order. And that's what happened. Again, I won't run through all of the grounds, but
yeah, Mr. Dawes, if you allow me, was there any writ schedule, produced then before the court, April or May? The writ schedule, the objection, materiality, and relevance of a document of both sides. Was there any one of this produced?
Yes, there was, and it was well over 100 pages. And of course, that's the position under Part 28. You produce the Redfern schedule. It's not, and the sort of application where you provide evidence. Your objections are set out in the Redfern schedule. And it's a complex and lengthy document. There are a lot of arguments traversed in it, and all of these points are raised in the grounds of appeal in Skeleton that were filed in support of the appeal. But I've been through a number of these processes. I've had a recent case.
What's the objection? What's the basis of the objection, if I may know? Is it like materiality, relevancy, or privilege, or confidentialities?
It's a collection of all of them, frankly. Your Excellency. So there are certain categories of documents which it's clear from the request being made itself that the defendant's already in possession of, because it's a request for production of emails which include the timestamp of the email, the precise individuals to the sort of information you could only really ascertain if you actually had the document in your possession already. There are categories like that. There are categories which deal with relevance and materiality. And in particular, as I said, there were, at an earlier stage of the proceedings, certain claims, counterclaims raised by the defendant for discrimination, victimization, and so on. And there were a raft of issues that were struck out by Justice Sir Jeremy Cook at an early stage of proceedings. And some of the document production requests go to those issues which have already been struck out. So that's things to do with the regulatory status and the DFSA authorization of the claimant entity, the first claimant, that is. So there are plainly issues with the substance of the document production application which needed to be vented and argued and determined by a judge. The grounds of the appeal in a nutshell, it's procedurally wrong and unfair to proceed to make such a lengthy and complicated decision about document production without a hearing at all. It was also procedurally wrong and unfair to issue the decision in the form that it did, because as Your Honour, as Your Excellency will have seen, the document production order doesn't contain any reasons. It just grants all of the requests and doesn't explain why, which, as a matter of due process, we say is improper. It also means that you can't, for example, challenge the substance of why a decision is made when it
That
comes
would
to
give the
appeal.
Court of Appeal hard time. I mean, the lack of reasoning as well. I mean,
precisely, and there's authority certainly in the English courts which deal with absence of reasons for decisions. In any event, we say that if you even go into the detail of some of the requests, it's clear that they relate to issues which were struck out, and so we say that it exceeds the ambit of judicial discretion on the substance. Even though we haven't got the reasons must be wrong, because there's no way that those documents would have been seen as reasonable and proportionate. And there are further grounds which include the impracticability of the order itself. So the idea that such a wide-ranging series of documents could be produced within, I think it was 12 days were given, we say would have been an impossibility anyway, because inevitably, if you're going to undertake such a disproportionate and wide-ranging search for documents, inevitably these things take time. And that's the basis of the appeal. After the appeal was made, there was also an application to stay that order, so to stay the document production order. That was granted. I don't need to take you to it, but it's at page 118 of your bundle. So that the current position is that any orders with respect to document production have been stayed. And then the final piece of this is at 120. The application for permission to appeal went to the first instance judge, and that's been granted on all grounds to be proceeding to the Court of Appeal. And one doesn't always want to read too much into the rationale given for permission to appeal, but the fact that the first instance judge who made the decision hasn't come back and defended the way the decision was made does somewhat suggest that it might have been made in error, or at least without the benefit of knowing that there were objections. Because what he certainly doesn't say in any reasons is, well, I considered the detail of this and I'm going to give you my reasoning in my rejection of an application for permission to appeal. That's not what's happened. We're proceeding to the Court of Appeal. As it stands, that hearing is listed for the 10th of October. And now I don't think it takes too much of a leap of the imagination to see the problems that that's going to pose for trial. The document production order is stayed. The appeal is going to be heard. Thereafter, of course, there's going to have to be a period of time for the Court of Appeal to consider the arguments and to render a decision. And there's obviously going to be some time in that. It may well be, given the nature of the appeal that we're pursuing, that the Court of Appeal might find it quite straightforward, but I don't think I'm able to speak for how the court might approach the decision, how long it's going to take. But either way, we foresee problems because on either outcome, one, the claimants are successful in the appeal, which we say is highly likely to be the outcome given the nature of the decision. If that happens, the document production issues are going to need to go back to the Court of First Instance. It's going to need to be listed for a hearing, and the court is going to need to make orders based on the party submissions of what's going to be disclosed and by when. If that happens, of course, a trial is not going to take place on the 26th of November, because the steps that have to take place between now and then are...
May I ask you this? Why didn't you try to deal with that case management order given by the small claim tribunal judge and sort of de novo review instead of taking it to the Court of Appeal?
So a de novo review is where there has been a decision taken by the registry, which can then go back for review by a court of first instance judge. But the Justice Nasser al-Nasser, in this case, as I understand it, will have been sitting as a court of first instance judge who made the decision. So your route of dealing with it are, if you have grounds to set aside, you can apply to set aside. But because the order wasn't made as though it was on the court's own initiative, that option wasn't open. And so appeal was the only route. Just to complete the thought, even if we get to a scenario where the defendants are successful on the appeal, leaving that substantial order for the production of, I think it's 65 separate categories of documents in place, that's still an issue for trial because it's going to take time to conduct the relevant searches. The part 28 of the rules is clear on this, which is that until you've got the full ambit of the order, you shouldn't be undertaking searches because it's a disproportionate waste of time and cost. So that process is going to have to start. The documents are going to have to be produced, and the parties presumably are going to want time before trial. Let
me ask you this: to what extent, and I'm guessing it's to a very large extent, the production would have an impact on what have been already produced as witness statements, evidence, expert evidence. Because I thought most of the evidence should have relied in the production, because we usually take production first, then witness statement, then expert report, and that everything would be built up based on the, production of document, because document is the main proof. I think in such relationship like the one we have in hand here.
From the claimant's perspective, we say that the witness statements have been produced and the expert evidence has been produced. That shouldn't necessarily be surprising because the document production requests that have been made, we are resisting on grounds of materiality and relevance. So we would say the fact that we have the witness statements and the evidence prepared somewhat suggests that the stuff that is being requested does not go to the heart of the issues at trial and are essentially disproportionate fishing expeditions, the defendant trying to get information as much as they can in order to harm the claimants. That's the long and short of it. So yes, the other steps in trial have been achievable. It's the defendant who has persisted in the course of seeking these documents. What we say about the procedural position proceedings are in now is either way, either outcome of the appeal means that the currently listed trial dates are highly unlikely, if not impossible, to adhere to. What we have tried to do in order to carve a third way through this is to give the parties an opportunity to reach some consensus that negates the need, one, for an appeal which we say the claimants are highly likely to succeed in, and two, the hearing that's going to come back before the court of first instance to have these arguments. And so what the claimants have therefore done is write to the defendant to make conditional offers to the defendant that if you agree that the appeal should be allowed and that the order should be set aside and that we can put an agreed position before the Court of Appeal, if we want to make the trial date, it's simply open to the parties to discuss and negotiate and come up with an agreed form of document production order. If that happens soon, then a November trial is possible. If it doesn't happen and the parties aren't able to reach an agreed position, we're probably going to have to look at our calendars and see when we can list a safer hearing window that will allow orders to be complied with, whatever those orders end up being. So the claimant's position this morning really is that the options are relist trial now or relist it later, assuming the parties don't agree. If the parties can agree a third course, then the trial might be maintainable, but that's probably going to be the only way to do it. And it might be that there's a degree of pragmatism that might be needed from the courts to determine what way forward to adopt. It might well be that Your Excellency fixes a period, say a week, 2 weeks, whatever it happens to be.
Basically, I can see the complexity of the Court of Appeal decided either to grant protection or to return the case to the court's first instance to recheck the relevance and materiality of the document, which might lead to another protection or another appeal based on another contest. So what I think in both scenarios, we can see there is a risk that the trial dates are not maintainable. Now, I don't know. I don't think while having a court of appeal set up for the 10th of October, then we can do anything. I wonder if between both of you, you could have agreed that to vacate the trial date and then wait the outcome of the production at the end of it, and then you can agree on another trial date. Because I can see how much cost and effort you put once you have a trial date and you have to, and then I might also understand how busy you are during the year, and I'm sure November is one of the very busy months, October, November, and just before Christmas. That is the peak of the lawyers' times.
Your Honour, sorry,
yes,
I didn't want to cut across,
yeah.
Your Honour.
Mr. Joyce, yes, please.
I do have some things to say.
I'm sure you have a lot to say.
Yes, and it's probably convenient if I say everything in one go, but I do want to put a marker down that I have things to say in this regard, but if Mr. Doherty is going to finish all his submissions in short order, I can deal with everything in one go.
Mr. Doherty, is there anything you would like to add? Because I can open, keep it in an open discussion, because I really understand this is, it's all about keeping the trial date more or less. If you don't mind, we can allow Mr. Joyce go on, and then I'll come back to you.
Sorry, I'm applying.
Sorry, I was just going to say that the only concluding point I was going to make is
yeah.
In terms of suggesting pragmatic courses, I think you've suggested one of them, which is await the outcome of the appeal. There were, I suppose, two things I would add to that. The claimants are keen to get trial on as soon as they can. So one thing that might usher that on, even if we relist the trial dates, is if at some point after we finish today, that the parties would be provided with a list of Your Excellency's dates that you're available for what a reconvened hearing window might be. So that's point one. And then point two is the parties are going to need to have discussions about the vacation of the trial date. One option that, of course, remains open is that they could agree in terms of a document production order and maintain the trial. But it may well be that you could put in a direction to that effect. But, you know, that's really, if the parties haven't agreed to the form of a document production order within the next week, say, then that's when the issue is going to arise, because the trial date starts to look more and more impossible to achieve after that. But I'll reserve anything else I have to say until Mr. Pratchett-Joyce has had the opportunity to speak.
Your Honour, I'm obliged. There is a graphic expression, making a mountain out of a molehill, which is blowing things out of all proportion. And that is really what is happening at the moment. The learned friend says that the claimants are keen to get the trial on, but everything that is said is designed and directed to a postponement of the trial date. The defendant is keen to get the matter heard as well, and everything that the defendant is doing is constructively directed to maintaining the trial date. My learned friend has spent a lot of time, although he said that there was no need to traverse the detail, he spent a lot of time going into matters which are properly to be ventilated and raised in the arena of the interlocutory appeal in relation to the document production order. And I have to say that we take substantial exception and issue with the way in which my learned friend has summarised the matter. we have based our requirement or our requests for documents on documents already produced, and we are not going over ground which is not within the four corners of the issues before the court. But those are matters for another day. And we know what that when that other day is. It's going to be the 10th of October, so not too far away. Let me stand back and just run through the complete picture, if I may, as we see it. First of all, the court has been taken to the court management order, the agreement, and there's nothing arising there. I think that's common ground. The Schedule C to Part 26 has been lodged. We've lodged ours dated the 30th of August. As Your Excellency is aware, the trial date is now fixed for the 26th of November, with a trial window of 4 days. And really, following on from what my learned friend has said, 3 + 1, there is a trial timetable which expands across the whole 4 days. But I think it's obviously therefore common ground that this is a trial window which will more than encompass the hearing which needs to be covered. And that's quite important in relation to timetabling. The claimants have now raised, and it's not they've raised it in correspondence earlier, issues over whether the trial date can be maintained. In our submission, the trial date can most certainly be maintained. We now know that the disclosure issues will be resolved at an interlocutory hearing on the 10th of October. Although one cannot predict with certainty, certainly from previous experience, the Court of Appeal is really very quick in relation to dealing with interlocutory appeals. That leads to our submission that 6+ weeks between the 10th of October and the 26th of November is more than ample time for the further disclosure to be reviewed and analysed and assimilated. In any event, and this goes back to the correspondence between the parties of which the court is aware, I won't, for reasons of time, take the court to the correspondence in detail. It's unnecessary. But since the 11th of July, the claimants have been making offers, open offers, to make further disclosure. That, in our submission, is a very good step, and it is bound to narrow, we don't know to what extent, it may substantially eliminate or totally eliminate the issues between the parties on disclosure. But the offer is something we welcome, and we have invited the claimants to follow through on that offer, which is now outstanding for some 7 or more weeks. What the claimants have sought to do is impose a condition on the offer that they have made. The condition that they seek is, if you like, an affidavit of non-possession, so that my client would have to swear an affidavit to say that he doesn't have documents. He's already said that. That is explicit and obviously necessarily implicit in the Redfern schedule, which has already been part and parcel of the document disclosure process, which Your Honour is now well aware of. There is absolutely no need to say again that which has already been said. He hasn't got the documents. And if he did have the documents, then they would be favourable to him and he would already have disclosed them. So in our submission, 2 matters follow. The time for further disclosure in relation to the matters which are the subject of correspondence, and they address, in one instance, 22 of the 72 items, in another instance 14, and those are not limiting the nature of the offer which has been made. If an offer has been made back on the 11th of July, 7 weeks have already passed when the claimants have known about the offer that they've made. So they have been in a position to take the necessary steps to provide the disclosure consequent on their own offer. So in our submission, the time for that further disclosure contained within the correspondence should be very short. It should be really forthwith. And forthwith is a matter of a few days, because it already has been in their express contemplation for over 7 weeks. It is also, we say, completely disproportionate for a party to be put to the expense of time and cost of swearing an affidavit to say something which has already been said. And that, in our submission, is the length and breadth of the outstanding disclosure issues as we know them. It may be that the claimants continue not to make full disclosure, even in the light of that which has been offered. But we'll cross that bridge when we come to it, and we are looking constructively at holding the trial date. The trial length, Your Honour, as you know, is 4 days. And one thing I would raise, and this is something which probably could be dealt with without court awareness, but I think it's only polite that the court should be informed. Because of the 4-day trial window, the defendant may wish to retain, and indeed is presently minded to retain, transcription services. And therefore we would ask for permission, formal permission, for transcription services to be included within the court facilities. We will pay the usual basis if the claimants wish to partake and take part in the transcription and sharing it with the court, then obviously costs can be shared. If not, then we would retain sole rights to the transcription, share it with the court. But if you don't pay, you don't get, so far as the claimants are concerned. So that's all I would say by way of trial length. So far as the trial bundle is concerned, that has been part and parcel of Schedule C to Part 26. The trial bundle will be completed by the 15th of November. That's our present intention, and that provides ample time again for preparation for the trial beginning on the 26th. As far as written submissions are concerned, we would propose really the usual order in relation to mutual exchange, probably 5 working days or whatever period of time is convenient before the first date of trial. One matter that I would raise in that connection, Your Honour, my learned friend has already referred to the fact that this case is quite law heavy, and cases which are law heavy need obviously an explanation of the legal framework and the legal principles which are applicable, and it can be simply more extensive to explain law than explain facts. And I'm aware that the limit on the page limit for skeleton arguments is 25, and it may be that we would need to exceed that. It may be that my learned friend needs to exceed that. It may be helpful, therefore, if the court formally allowed an increase to, say, 40 pages, but obviously on the basis that we're not going to abuse that indulgence by the court. If the matter can be said in 20 pages, it'll be said in 20 pages. If it can be said in 25, it'll be said in 25. But if it needs an extra few pages fully to articulate the points, we would ask for that flexibility without the need to make an urgent application for dispensation close to trial. Witnesses, for the claimants, there are 4 witnesses of fact and 1 expert. For the defendant, it's the defendant himself and 1 expert. So the court will note that there is a substantial difference in the number of witnesses. And of course, it's for the claimant to prove their case, and they must call the witnesses to do so. But equally, the defendant must have a fair opportunity to test that evidence through cross-examination. There is at the moment a trial timetable passing between the parties, but that does not strike a fair balance with regard to cross-examination. What in essence it does is it allows the defendant about 5 hours to cross-examine all 4 of the claimant's witnesses, and it allows the claimant 6 hours to cross-examine the one factual witness being put forward, i.e. the defendant himself. Now, obviously, that's not a fair balance, but going back to the relatively generous overall time frame of 4 days, we say that the cross-examination aspect can be covered without being too prescriptive, in that there is likely to be fat in the 4 days anyway. One particular area of fat in the 4 days is that at the end, it's proposed that each side would have 2¼ hours to make closing oral submissions on the back of evidence which is absolutely fresh in the court's mind. We simply don't think that both parties would need a combined total of 4½ hours to do that. We think it could be done in an hour each. Well, if it's an hour each, then there's obviously a very substantial saving even there of over 2 hours. And if we have reasonable flexibility, reasonable elbow room, then it seems that the fair opportunity for cross-examination can easily be accommodated without being too prescriptive in the trial timetable. The final matter that I would raise for the court's consideration is the trial format. And at the moment, the trial format is for the hearing to be held remotely by video link. Now, of course, the hearing involves live witnesses, and everyone is well aware that the court is very often assisted by seeing live witnesses give their evidence in the precinct of a room where everyone is gathered together, so in person. And we think that that may well be of assistance to the court. Obviously, it's a matter for the court's discretion. But the factors which we've identified is that the claimant's legal representatives, other than Mr. Doherty, the claimant's legal representatives are based in Dubai. The defendant's legal representatives, those instructing me, have offices in Dubai and are well versed to being in the jurisdiction. Both my learned friend and myself, although based in London, are again well used to the DIFC jurisdiction. The defendant is resident in Dubai. One of the experts is resident in Dubai. One of the experts is resident in London. The main witness for the claimant is Mr. Chin, as I believe, resident in Dubai. One of the other 3 witnesses is also resident in Dubai. So there are, I accept, 2 witnesses on behalf of the claimant from outside Dubai. But at the moment, the trial timetable is encompassing full days. And of course, by the time we get to November, the time difference even between the UK and the UAE will be 4 days. And one of the witnesses is, I think, based in Hong Kong. The other witness may be based in Hong Kong. She may be even based in the States. But that, in my evaluation of all of the relevant matters, is an important consideration, because we need to have a complete day when everyone is able to accommodate that complete day within their own time zone. And if we're all gathered together in the same time zone, it dispenses with those issues across the board. And as I say, those issues are not simply limited to the then 4-hour difference between London and Dubai. It encompasses wider time differences which extend to Hong Kong and elsewhere. It's obviously a matter within the court's discretion, but I raise that for the court's consideration. So, in summary, so far as the trial date is concerned, we say it should be maintained. We say there's really no pressure. There should be no pressure, given that the claimants can substantially meet the issues now. And in any event, we'll have over 6 weeks between the 10th of October and the 26th of November. So we say trial date should be maintained. Trial length is relevant for the purpose of transcription services, and we'd ask for permission for transcription services to be included within the running of the trial itself. Trial bundle, I need say nothing more about. The written submissions I've dealt with, and particularly the permissive request to exceed 25 pages if necessary. So far as the testing of evidence is concerned, the present timetable of an absolutely equal split of time between the parties does not cover the disequilibrium, the imbalance in the numbers of witnesses to be tested, but we can accommodate that with reasonable flexibility within the existing timetable. And the trial format I raise for the court's convenience as to whether holding it remotely and by video link is actually the most optimal approach. My co-counsel, Mr. Matu, is on the call. We're not in the same room, so I'm not able to turn to him or have a metaphorical tug on the gown, but he is in WhatsApp contact with me, and I haven't seen a message that I should raise any further points. So unless I can assist you further for present purposes, those are my submissions, Your Excellency.
Thank you very much, Mr. Joyce. It's you raise very important and interesting points. I mean, if you allow me, well, to start from where you ended, the physical trial, I do prefer and encourage a physical trial in the presence in the courtroom. I would also invite Mr. Doherty to consider this request, and I think it's in the best interest of all parties, I guess, in my assessment. Mr. Doherty, I would invite you to consider this option, and if you can accommodate it, then that's the best. I might understand you might have witness outside the country that can be dealt with. I don't think it will be for one witness or one expert should not add a lot of cost, I mean, to the proceeding. That's the first point. And then when it's come to the trial and the transcription, live transcription, I do agree. I don't have any issue against that. I do encourage it. It's actually it would help parties to deliver a better closing submission, and that would help the court to have a better view of the issues between parties.
As to those points. Sorry, I thought you were finished.
No, I'm not. But yes, listen. I mean, this is my initial views. I mean, if you agree with me, you can say agree. I mean, but I will come, and then I'm going from bottom to the top. I will go finally to the trial dates. I mean, whether if it can be kept or not. I mean, the extension of written submission is beyond 25 pages. I might be flexible with that too. If parties could agree in that, that's fine. Otherwise, I do have the habit of extending beyond the 25 pages, but not beyond 40 for sure. The length of a trial, I can see, but the time allocated to cross-examine each witness, I think it depends on the length of witness statement itself, the amount of information, facts, and evidence contained in each evidence, I guess. So we apply more proportionate instead of allocated a time for each witnesses. I think sometimes the importance of witness statement would necessitate a lengthier cross-examination for each witness than other witnesses. So I don't have issue that Mr. Because I do believe that Mr. Imran is the most important witness in this case. So, and I think cross-examination of Mr. Imran Khan can be the lengthiest cross-examination at this trial. I mean, by the claimants, and it's not a big issue with that. I will go back to the maybe for now. I mean, before I come back to you, Mr. Doherty, Mr. Joyce, which I would invite you to give me an answer, a quick answer for this before I turn to Mr. Doherty to answer it. I mean, having the trial for the appeal court 10th of October, I said we don't have the. You might predict if you trust this court, if you understand this court, if you understand how those judges work. Usually, there might be sort of a prediction or anticipation what kind of outcome, but even with that, can't be certain. We do have party submission. We do have a disagreement over hundreds of pages and of different evidences. What I'm taking into account as well what the claimant have already commented in certain cluster of or certain documents already. So the court might take that into account, or the claimant being in a discussion or have produced its opinion about some documents in the production list. The court might take that into account again. But I do take into a very deep concern what Mr. Doherty said. What might be the outcome of the Court of Appeal in relation of that appeal? It could be really, it could be something really easy, and then they would just reject the appeal. Production is to be produced maybe within 10, 15 days, 5 days. I don't know. You might, as you might say, Ms. Beatrice Joyce, that the claimant already aware what kind of document they should have been aware of that. That would be anyway. The Court of Appeal would decide even the time frame for such a production. We didn't know. Maybe one. Well, usually they give 2 weeks. I mean, maybe more, maybe less. We're not sure. And I asked this question before: to what extent this document? I mean, this document or this kind of document would have any impact. There will be extra or further witness statement to be given against this produced document. Would the expert are to be re-engaged with this document? Is it? As I said, I'm not looking at the appeal right now. I'm not sure if any of this document would have led the expert to change their minds about even the quantum. I'm really not sure, but I can see that complexity. Mr. Doherty try to take the court to extend where he said it's risking the attainability of the trial date. I might see that whether the Court of Appeal decision there is a possibility, maybe it might be 10%, maybe 20%. That's the Court of Appeal decision, whether direct dealing with the production of documents appeal or returning the case into the lower court to decide on it again. The impact of the lack of reasoning in the Court of Appeal action. I think it's surrounding this with sort of ambiguity, for me at least. I mean, Ms. Doherty agrees with me. I can see there is a slight risk of very tight timing between the end of the production and then the parties to deal with it, especially you, Mr. Joyce. I mean, you would be the receiving parties. You would receive hundreds of documents. I mean, you can tell me. It's I think this is the positive part of it. Is you are the receiving party of the documents. It's not the claimant who's supposed to know about it. He's not relying in this document, but you, the one who wants to rely in this document, because you the one who apply for this document to be agrees. I mean, So the balance for probability in this at this moment is maybe on your side. If you said, I would take this document in 2-3 weeks time and I would deal with it, and I have and the time to trial is insufficient for me to produce whatever I want to produce based on the produced document, and then that is your responsibilities, and I'm sure you will not then allow to apply to extend the trial time.
Yes.
I would like you to enlighten me again, in short,
Yes.
about these complexities related with this application before the Court of Appeal, and whether it's really going to lead to any delay in the parties' preparation to the trial.
Indeed. Your Honour, let me take the points again, perhaps almost in reverse order. First, Your Honour is absolutely correct that the risk is on my shoulders, my legal team's shoulders, my client's shoulders, and that is a risk that we are prepared to take. The second point on which I agree with Your Honour is that one cannot predict the future, and no one can in any circumstance. So what does one do in what is the next best, other than having a crystal ball to see what would happen if we went down a particular route? Well, the way in which, in my submission, one approaches it is to look at the surrounding circumstances. And here there are two. The first surrounding circumstance is the open offer made by my learned friend and his legal team, which is now of 7 weeks.
I'll come back
it's not
to
an open offer.
Let him finish.
I'll make the submission, but it's wholly misleading to present it as an open offer. And I feel I need to interject at that point.
Didn't go that far, Dorothy.
Right. It is an offer made in open correspondence. We can all read it. We all have read it. It has a condition attached to it. And I've dealt with the condition, which I say is utterly insubstantial. But so we can narrow the scope through constructive approach on the part of the claimants. We, in any event, have a period of over 6 weeks, very nearly 7 weeks, but over 6 weeks between the 10th of October and the 26th of November. When you go back to the original order for disclosure, the original order for disclosure provided a time in days. I think it was 12 days, we can turn it up, but it was a matter in days. And therefore, although Your Honour is right to say, well, the period of time within which disclosure would be ordered is an imponderable because it's a matter which would be determined in the future, in my submission, to extend that to a month is to go beyond the 40 pages of a skeleton argument. It's excessive. More than 40 pages would be excessive in a skeleton argument. Allowing a period of a month for further disclosure would be excessive in this context. And therefore, looking at that and applying the fact that that period of time would be excessive, it should be a matter counted really in days. And given that we have over 6, nearly 7 weeks between the appeal hearing and the first date of trial, that is what gives me confidence in saying that the disclosure matter can be effectively handled.
I think you should discount 2 weeks or 14 days at least, because that's the time allowed, even if the court with you. So you would need to discount 2 weeks from that at least. And then you would discount 1 week because you need to deliver, let's say, 5-6 days before the trial.
Yes.
So I think maybe, in fact, you got 3 weeks to deal with it. I think that is very tight. I mean,
well,
I don't know. I'm expecting Mr. Matu to pop up on my screen anytime he says it. I'm with the claimant side now.
We accept that obviously time is time, and I accept the points that Your Excellency has raised. Yes, let's take 2 weeks. Let's take the fact that the submissions would be 5 working days beforehand. It's over 6 weeks from which one's deducting the time, so it comes to a period of over 3 weeks. that is over 3 weeks to deal with documentation which is in supplement of that which is already available and before the court. Yes, it means that we have to crack on with it, but we're prepared to do that.
Oh, that's tough. I better.
Sorry,
I said that tough, but if you think it's realistic, my greeting. Mr. Dirty?
Yes, Your Excellency, I have quite a few points to make. I mean, the one at the outset is that when one doesn't know exactly what's going to happen in the future, you can make projections about what's going to happen. You can make it based on reasonable inferences and expectations of what's going to happen. And it's tight for reasons I'm going to come on to, impossibly tight, even if you adopt the fundamental assumption which my learned friend has, which is that the defendant is successful in the appeal. But Your Excellency might have had a view already when it comes to a 100-plus page red fern schedule containing 65 disputed categories of documents, where one has an order which was made without reasons and without hearing from the parties whether that's in fact a relatively straightforward appeal to the claimant's advantage. And of course, if that's what the Court of Appeal decides, then there's a whole other process which is going to need to be started from the outset, which is listing document production application for a hearing and dealing with all of the steps after that. So what you're having to weigh up is the outcome of both possible permutations. And if it's impossible in both permutations, the risk here to the parties isn't about the merits of the case, it's about them going to the cost of preparing for a full trial, only to have to vacate it 2 weeks in advance. But just going through the number of different points my learned friend has made, this characterization as an open offer, I have to say, it's very disappointing that that sort of submission would be put before the court. And I really don't make a habit of using this term, but it is a misleading submission. And it's one that we say it's extraordinary that the defendant is still maintaining. The regime under Part 28 encourages the parties to cooperate. That's clear. And there's authority from Justice Martin dealing with this point and stressing the importance of the parties' cooperation when it comes to issues of document production. The letter that has been sent is in that spirit of cooperation. The whole point of the regime in Part 28 is to try and avoid issues coming before the court when they don't need to. And so there are a number of provisions in the rules which say when it comes to electronic searches, for example, you should have discussions about what the search terms should be, when they should be used. In advance, where possible, you should have discussions about what categories of documents might be accepted and so on. And the rules are equally clear that you only begin the process of actually searching the documents once you've got the agreed parameters of what it is that you're going to look for. And that's enshrined in Rule 20.24, which says the parameters of the searches should be referred to the court for determination before any relevant search is carried out. And it says this is particularly important where the volume of documents to be searched is large, or the searches are likely to be time-consuming or expensive. And the logic of that process in the court's rules is clear, which is, from the claimant's perspective, what we're not going to do now is to pick through 65 categories of documents, search them all, decide what's relevant and what's not relevant, and have a core of documents for disclosure, which the defendant says, no, we don't accept that. We're going to the court to ask for different searches to be run for different documents to be disclosed, and so on. And that's why it is extremely misleading to characterize this open offer. The offer that has been made is to short circuit court dispute and court process regarding the production of documents. It's not a quid pro quo, as my learned friend put it, for an affidavit. That's one component of it. But the key component of it was to put the defendant on notice that we're now in a situation where the parties are staring down the track, facing an appeal, which is going to cost money and time, and a document production process after the appeal, which is going to cost money and time. And we've put to the defendant an alternative way where we don't have to incur the fees of going before the court twice to get to a position when we could just agree it. So if you consent to the appeal, consent to the order made for document production being set aside, and you agree to drop your document production application, here are the categories we'll give you. If you don't, then we'll proceed with the appeal and we'll proceed with the document production hearing that will take place after the appeal. That's the position, that's what the letter deals with. If we don't agree, we go to a contested application where all of the claimant's objections are maintained in full. And that's precisely what's envisaged by Part 28. And it doesn't take a lengthy reading of Part 28 of the rules to understand that that's what the court intends. So that's the first point dealing with the letter. If I can deal with the timetable for production as well. So even if we assume the defendant's best case scenario, which is that the order for the production of those 65 categories of documents is upheld in appeal, the timetable for production is itself a ground of appeal. So that was that there's a ground of appeal which says 12 days for the production of this extensive a set of documents is impracticable. You cannot do it. And there are various different reasons for that. They're set out in the skeleton that went to trial, but it gives some comparative examples of how the court has dealt with this in other cases. So, for example, one of the comparative cases given is a recent decision by Justice Lemiere, AES International and GSB, and that dealt with requests for disclosure of 16 contested items, so considerably fewer than there are in this case. And that returned, I think, something like a 76-page judgment, setting out the different categories, so reasoned analysis of why they were made, point one. But in the end, the document production process there was fixed for 45 days. And in fact, even that was extended. And the reason is, if you have lengthy and complex sets of searches, it is inevitable that those sorts of searches take time. And again, I won't run through everything, but some of the examples of the requests in this case that were referred to in the skeleton argument, there's request 17, which is WhatsApp chats, which includes bilateral chats of any of the claimant's employees, covering a period of 2 years on any issue concerning these proceedings and the defendant. If you let me finish,
I'm sorry to interrupt, but I'm sorry to interrupt, but these are matters for the appeal. They have got nothing to do with a pre-trial hearing. The points must be made.
Well, exactly. My role here, just to decide today whether courts will be in physical or in,
of course,
yes, or whether then the trial date is kept, the length of the trial is reasonable and proportionate or not. That's what I'm going to decide here. You know what I mean? Yeah, I mean, you have a lot of things. You have a lot of things to say before the Court of Appeal. The Court of Appeal will decide this. I'm sure, but there is an assigned court to deal with it. Already, you have a submission to do. I can't tell you what is my roadmap. It look like. I can't tell you what I'm thinking now. Literally, I just put you how I'm thinking. Well, maybe what I'm thinking. Unless you agreed in the next, let's say, in the next 10 days or 15, next 2 weeks. Unless you agreed in the next 2 weeks on any, let's say, way of production between both parties. Otherwise, I can see that. Otherwise, the Court of Appeal having to decide the production of document is making a huge risk and keeping the trial dates as giving for now. I mean, I think the agreement, only the agreement would really survive the trial date, the time that week.
Yes.
Of November. But
And to be clear,
I have seen the, I do see the difficulties. I said, while you submitting before me, I'm exploring all options before me. And we understand different judges has also different views. You know what I mean? And I said,
course.
yeah, it could be a piece of cake. You know what I mean? Appeal is granted, no production, the end of the story. You know what I mean? We can go back to trial date. Appeal appeal is appeal is rejected, the decision is upheld, then the complexity starts. And that even would have many options. We didn't know how many days would be given for the production. We didn't know how many categories is allowed to. We didn't know if all categories would have a similar production time or not. I really, I can see the difficulties of this. I mean, I prefer to work based in certainty. Certainty is much better for all of us, Mr. Bashir Joyce. Even for yourself, even for your team. You know what I mean? It's what's the point? Is like we insisting in a trial date, and then we just said, oh, it's not practical. Even if you might say, oh, well, it's enough for me to deal with it, even if I have, then the other party would need to deal with what you have relied on just recently because of a court order. You know what I mean?
Well, Your Honour, may I say that I'm grateful for Your Honour's indication, and I'm rather attracted by what Your Honour has said, or Your Excellency, my apologies. Your Excellency, the starting point is that both parties do want, if at all possible, to hold the trial dates, and my learned friend has said that in terms, and I've said that in terms. So it's not an assumption; it's a standing position of both parties, and there's commonality there. Your Excellency has also drawn attention to the fact that there is a period of time, between now and over a month's time, when the Court of Appeal will hear the matter, and it is not out of the ordinary for a listing date to focus minds. So, given that both parties do want the trial date, there may be scope for following Your Excellency's indication of allowing the parties 2 weeks to seek to agree a way forward on production of documents. If that succeeds, all well and good. Even if it doesn't, it will be far from wasted time, because it will be focusing everyone's minds on that which is already in the diary for the 10th of October. So even if there is no agreement over the course of 2 weeks, the time will have been constructively used as preparation time. If there is agreement, or if there is partial agreement, narrowing of the issues, then all of that is constructive. And it may well be that the appropriate way forward, picking up Your Excellency's indication, is to hold over for 2 weeks the vacation of the trial date, deal with all of the other matters properly within the pre-trial hearing, which I've covered, and where I don't think there's a lot of difference between my learned friend and myself, if indeed any difference at all, and that we see where we are in 2 weeks' time. If there's been absolutely no agreement and it's clear that matters are going to go to the appeal court, then that perhaps indicates that the outcome will result in vacation of the trial date. Not that either party wants that, but we will at least be able to take stock with a much greater information on the one big issue, the one big issue between us. And I don't know whether that sort of approach commends itself to the court.
Mr. Doherty?
Yes, Your Honour, I think that was the approach that I'd suggested at the outset of the hearing, and it seems pragmatic, but what I'm conscious that we don't want to do is to waste time. I think the purpose of my taking you to the last submission was not to say this is what the Court of Appeal will find. It was to say, even if the Court of Appeal finds in this way, we're still looking at a chunk of time that's going to be needed to go and actually run searches on electronic documents if the document production order was upheld in full, which I think Your Excellency appears to have reached the position that, you know, even if one assumes speed from the Court of Appeal and you get a judgment in 3 weeks, to fit into that 3 weeks, the searches, whilst simultaneously preparing for trial, preparing bundles and so on, and that's why we say on either course that it can't be maintained. I agree, and you know, as I proposed at the outset, if the parties can reach agreement to maintain the trial, then they should. I would perhaps suggest that 7 days would be better than 14 in focusing minds. The other matter that I would add to that is to say that so that we're not losing windows
I wonder why
of time.
would you reject 14 if it's work in your favor? Because 14 is not just for your opponent, it's even for you. I mean, the court generosity will work well for yourself, even for your parties, for your client interest, that to reduce costs, not going to court of appeal, and reduce costs, not even delaying the trial time. So in your favor, as you said, it's your top priority is keeping the trial date. So you better utilize what time is given to you by the court, Mr. Doherty. That I would think you would show some appreciation by the court giving you extra time to think about your case and to be the judge of your own matter.
But of course, I think what I'm mostly conscious of is when costs will start to tick up for preparation for the substantive appeal. If what we're talking about is on the expiry of 2 weeks, say from today, we're talking about the order actually biting and the trial date is vacated, then I think, as I say, 7 days might focus the minds more, but we don't have any particular objection to 14. The other point that I would add to that is...
Excuse me, what difference it would make, I mean, for when, if to know, and when the difference of 1 week for knowing whether the trial date would be shifted or not, what major difference it would make for you?
It's the idea of the parties agreeing presupposes that the appeal itself would end up being vacated, because the point of the parties reaching an agreed position on document production would be so that the appeal is unnecessary. And so the time frames...
I didn't get you. I think you're contradicting yourself. I'm not sure. Would you rephrase that?
If the parties are going to reach an agreed position on document production,
right,
the appeal on the 10th of October won't be necessary because the parties will have reached agreed positions on what the outcome of document production is going to be.
Right.
So what I'm trying to avoid is a situation in which the parties have agreed after costs have already started being incurred, more costs have been incurred on the appeal, which is why I'm suggesting getting it done sooner rather than later is better. But I think I'm not going to push too hard against that, Your Honour, or Your Excellency. If you prefer 14 days, we can live with 14 days.
What's the deadline for you to have your skeleton argument for Court of Appeal? Is that just after October, isn't it? It's in October, isn't it?
I would assume it will be. I would assume it will be a week
5,
before.
6, 7th of October, maybe. Yeah.
Yeah, it might be. But yes, there's the observations I make.
Then
you
got 4 weeks. You got 4 weeks after the 2 week.
Yeah, I'm not going to press on that point. What I was going to add to that is,
well, your opponent said I can be prepared for the major for the big trial in 3 weeks' time, and you said I cannot be prepared for appeal related to production document application in 4 weeks' time, Mr. Doherty.
I'm just conscious of how early in.
Well, I think you better utilize.
But I'm not.
You better use the 2 weeks to think about this here.
Yeah. The other point would be that in order to ensure that in the event the parties don't reach agreement, we can get a trial on as soon as possible, or diary gaps disappear.
But if you don't reach agreement, you appear before me in short. In 2 weeks' time, okay, and in 20 minutes we will be able to decide whether to keep that trial date or not.
I was actually just going to suggest, as a matter of pragmatism, whether
Or you can
Your
deal,
Excellencies,
with it on paper even, yeah. So.
yeah, dates of availability could just be sent out after this hearing so that the parties know
Of
what
course,
we're talking
yeah.
about. That was going to be my
Yeah,
suggestion.
that's good. Okay, okay. And before I jump to the other side, I would like to ask you a couple of questions for confirmation of a couple of matters that raised by your opponent, whether are you able to agree that the trial would be held in the courtroom physically or not? Or you will need to seek instruction?
I can only speak from my own perspective. I'll need to seek instruction when it comes to witnesses and so on. The current listing has proceeded,
November,
and
yes.
that has proceeded on the basis of it being virtual. And I think that, myself included, the time that has been allotted to that has not factored in additional things like travel time and so on. So I think it would be difficult at this point, it having just been raised, to now convert that to an in-person trial. But if we end up relisting, I would be happy from my own perspective to revisit the point, but I'll need to take instructions and check how that affects witnesses and so on. And so if we can...
What's the best time to decide this, you think? Like 1 month before the fixed trial, whether November or Christmas time, or I don't know when? Do you think 1 month would be sufficient to decide? Well, I remember in one case, in one of the cases, we have decided it in 2 weeks' time before the trial. But anyway, yeah,
decided the listing format.
Yeah, the listing format, yes.
Yeah, I think because I think we've got people attending from we would have people attending from various different places. Longer would be better, but I think what I would propose is, when we get Your Excellency's date, we can have in mind your indication of a preference for an in-person trial.
You can take this you can take it as a takeaway until the next 2 weeks' time when we meet or hear from you for next time. So
yes, because
you might discuss it with your client. You might seek direction. How about the live transcript? I think you're okay with that.
Transcription, no issue.
No issue. Okay, no issue. Do you? How about this written submission? Length of written submission?
Yes, I would encourage whatever approach we take to have a page limit, so that you don't end up in a scenario where the parties are aiming for completely different lengths. But if it creeps over between 25 and 40, I can see it being
40 is the maximum. Issue. Yeah, I'm saying 40 is the maximum. You okay with that?
That's fine. The only thing that I would latch on to that as a point is to say that this case is probably going to have submission on issues of law, because there are contractual issues, but there are also issues of breach of fiduciary duty and so on.
I don't know why I do have that feeling the discussion will be mainly about evidence. Well, I understand the law, I understand the breach of duties, the breach of fiduciary duties, and I have seen some of that too, where it's contractual terms as well. But I don't know. I can't sniff it out that there's going to be a lot about the evidence as well. Evidence is going to take a huge part of your submission.
I agree, and that's, I think, why there's a difference between the party and the amount of time that has been allocated on the timetable to closing submissions, because experience suggests that, including trials that I've had against my learned friend, and he will recall, often the final day tends to be eaten up by not only the time allocated to closing submissions, but also the judge telling you, this is what I'm interested in, this is what I want to hear from you on, and there's always a bit of a dialogue. And that's for a trial like this.
I can tell you, your opponent meant if you have covered most of the legal issue in your opening submission, you didn't have to repeat yourself over and over. You would just need to deal with the evidence, or the mainly cross-examination, and then turn into some main principles. So I know a lot of skilled lawyers do even in 45 minutes. They do submit after 6 or 7 days a trial in 45 minutes. And then they said, we can't, there is nothing to be added.
Our timetable somewhat allowed for a more
2.5
traditional style
hours
opening,
for now?
traditional style shorter openings with longer closings, because the court might be more assisted to hear.
Well, I can see the
legal
fourth
submissions at
day
the
is
end.
mainly for closing submission, isn't it?
Yeah, and of course, there's always going to be elements of flexibility and management of timetable on an ongoing basis. The other point in timetabling, I think Your Excellency's made the same point, which is you can see from the pleadings in this case that the central witness of fact is the defendant. The issues that are going to be traversed and which are going to be relevant to some of the more complicated issues you're going to have to determine are going to arise from his evidence. And so the split between the parties shouldn't be by number of witnesses. It needs to be by reference to the importance of the evidence that they give.
That's what proportionality dictates, I guess.
Yeah.
So what's left? Only
I think that was I think those were all of the, I suppose, the case management points that we had discussed. It may be that I've missed one, but I'm sure Your Excellency will tell me if I have.
I think this is most of it. This is my checklist. It's
which I suppose then brings us to what needs to be produced after the hearing today. I presume is a form of order, which the parties will draft and send to Your Excellency, but which effectively says by 2 weeks from today, which will be the 18th, the party shall inform the court whether they've reached an agreed position in respect of the appeal and the document production application. And if they have not, then the trial should be vacated and relisted for, and will hopefully include a date.
What is it? Okay, I'll 18. Yeah, I would say 19th because it worked toward the end of the week.
Just to cover the points. So
19th of September, yes, you would, yeah. And then,
so 19th of September.
It would update the court whether they reach an agreement in regard of the production of documents. Otherwise, the court will decide whether. But I've here we have explored most of the. I think the options related to the appeal and what. And I think everything said about that. We didn't need to repeat ourselves about it. The court would determine after your submission. I mean, your submission must be short, whether you reach an agreement or not. But if you have not reached an agreement, but if you are really if you needed 1 or 2 days, like maybe Friday, Saturday, I would still can accommodate that. But if you think there is no hope by then I would decide whether the trial date is kept or not, and then I will personally, and you might in that letter also, if you think it's not, and as a claimant you think the trial date should be moved on, then I might, if I decided to vacate the trial date, I will give you 2 options at least for the December and January as well.
You can take that. If the next 2 weeks the parties engage the registry to find your dates, so that when we write to the court in 2 weeks' time, we've had the chance to consider those dates.
If you would like to consider the production and the date as well together, if you want to move, deal with everything, if you think that during your negotiation, you would think there is a necessity to push the trial date, and then you might even anytime ask me through the registry, and I can provide my alternative dates to you. But if you're reaching no agreement at all, then I would decide whether trial date is kept or not. Great.
Your Honor, I'm very much obliged. And I've tried to mirror the keeping of notes, and I think that we've either got guidance in relation to the timing for an attempt to agree, which we're grateful for, or there's nothing between my learned friend and myself, save on the whether the hearing should be in person, and the consensus seems to be that it should be in person. My learned friend has...
That's my preference.
Yes, my learned friend has 6 weeks I think, to make appropriate arrangements for factual witnesses to attend. And I would hope, along the lines of the indication already given by the court, that such directions have been given by the court and adhered to by other parties in much shorter periods of time, that if the trial date of the 26th of November and following holds good, then we will have factual witnesses in attendance in person.
Sorry, I just have to jump in. I don't think I did say that there was consensus on that point. I said I would take instructions on that point because I can't speak for witnesses. But what I did say is that when it comes to the November date, my own attendance in person will actually be difficult because it had been factored into my diary on the basis of a virtual hearing. But if it is to be relisted, that we would take into account judicial preference and try to make that happen as best we can and put that position before the court.
And keep it in mind, Mr. Doherty, even if there is, I mean, we cannot let just one witness to jeopardize the main fact that we prefer the court's decision to be in physical presence. So if you have difficulties with one witness or one expert, we might accommodate that one expert or one witness online and then do the rest of the trial in person.
And I would
of course, this is the other thing
try
we
to
need
protect
to look at is
try to protect the principle that we should gather here in Dubai.
Yes, presumably that will also have an impact on dates because check the courtroom's diary as well. We'll have to the court is actually free.
Mr. Doherty, I do encourage you both really to work hard in these negotiations, and I'm sure you, with your experience, you would reach an agreement, and you would spare your parties another trial and delay of this matter. I'm sure your clients wants to wrap up this matter as soon as. I'm sure you would do.
And with a matter of this length, one always includes preparation time before the date of hearing, and therefore, with will, there should be ample opportunity for my learned friend to attend in person. And I hope that he will regard his diary constructively in that regard, because once again, it seems that potential hurdles are being raised to an early hearing of this matter, and we're concerned that that should be the case. But I don't push it any further. I'm sure that we can talk between ourselves.
Yeah, there is one matter, I think, since we agreed that the written submission might go beyond 25 pages each, I would urge parties that to at least I have the late submission, like at least 5 working days before the trial. But that would say 18th or 19th, depends on if we kept the trial date. I mean, I'm very hopeful that you would keep it. Let's say by 19th. I would have the written submission by the 19th of November.
Yes,
I hope that's all good.
That's noted.
Great. I don't think there is anything left for discussion for today. I thank you for your presence and for your submission. I will be looking forward to hear from you a good news by the 19th of September. If you reach agreement prior to that, I would welcome that too. Yeah, but in case of complexities, I would urge you, Mr. Doherty, to use the time given to you by the court to the maximum.
Yes, well, the conditional offer is with the defendant, so it's really a matter of how quickly they get back and say yes or no.
I trust you are a good officers of this court, of the justice too, and I have great confidence in you all, and I wish you a good discussion time.
I'm very much obliged, Your Honour.
Same wise.
Thank you.
Thank you very much.